Hey everybody, this is Ryan McClanahan with HistoryThroughCards.com. Hope you're all doing very well today. I was always really curious as to why and how eBay started to collect taxes, even though they don't have a physical presence in each state. And I found a really interesting document explaining this, and it is actually a legal document, Wayfair versus South Dakota. And I'm going to actually read just the dissenting opinion by Chief Justice Roberts instead of the entire document because it is actually 40 pages. I will actually leave the whole document in the description below so you guys can click on that link and read it for yourself, especially if you have a hard time sleeping at night. That might be a cure-all. But um, I'm actually going to read the majority of this dissenting opinion and see what I come up with at the very end. Without further ado, here we go. The Supreme Court of the United States, South Dakota vs. Wayfair, Inc., June 21st, 2018. Chief Justice Roberts dissenting. In National Balance, Inc. vs. Department of Revenue, 1967, this court held that under the Dormant Commerce Clause, the state could not require retailers without a physical presence in that state to collect taxes on the sale of goods to its residents. A quarter century later, in Quill Corp. vs. North Dakota, 1992, this court was invited to overrule Ballas Hess, but declined to do so. Another quarter century has passed, and another state now asks us to abandon the physical presence rule. I would decline that invitation as well. I agree that Ballas Hess was wrongly decided for many of the reasons given by the court. The court argues in favor of overturning that decision because the quote Internet's prevalence and power have changed the dynamics of the national economy, end quote. That is the very reason why I oppose discarding the physical presence rule. E-commerce has grown into a significant and vibrant part of our national economy against the backdrop of established rules, including the physical presence rule. Any alteration to those rules, with the potential to disrupt the development of such a critical segment of the economy, should be undertaken by Congress. The court should not act on this important question of current economic policy solely to expiate a mistake it made over 50 years ago. This court does not overturn its precedents lightly. Departing from the doctrine of stare decisis is an exceptional action demanding special justification. The bar is even higher in fields in which Congress exercises primary authority and can, if it wishes, override this court's decisions with contrary legislation. In such cases, we have said that the burden borne by the party advocating the abandonment of an established precedent is greater than usual. That is so even where the error is a matter of serious concern, provided correction can be held by legislation. We've applied this to heightened form of stare decisis in the Dormant Commerce Clause context. Under our Dormant Commerce Clause precedents, when Congress has not yet legislated on a matter of interstate commerce, it is the province of, quote, the courts to formulate the rules, unquote. But because Congress has plenary power to regulate commerce among the states, again, that's in Quill, it may at any time replace such judicial rules with legislation of its own. In Quill, this court emphasized that the decision to hew the physical presence rule on stare decisis grounds was made easier by the fact that the underlying issue is not only one that Congress may be better qualified to resolve, but also one that Congress has ultimate power to resolve. Even assuming we had gone astray in Bellis Hess, the very fact of Congress's superior authority in the realm gave us pause and counsel, withholding our hand. We postulated that the better part of both wisdom and valor may be to respect the judgment of the other branches of the government, recognizing that stare decisis has special force in the dormant Commerce Clause text due to Congress's final say over regulation of the interstate commerce. The court thus left it to Congress to decide whether, when, or what extent the states may burden interstate mail order concerns with a duty to collect use taxes. This is neither the first nor the second, but the third time this court has been asked whether a state may obligate sellers with no physical presence within its borders to collect tax on sales to residents. Whatever sales the adage third time's a charm has in daily life it is a poor guide to Supreme Court decision making. If stare decisis applied with special force and quill, it should be an even greater impediment to overruling precedent now, particularly since this court in quill tossed the ball into Congress's court for acceptance or is not as that branch elects. Congress is now free to decide the circumstances in which the states may burden interstate concerns with a duty to collect use taxes. Congress has, in fact, been considering whether to alter the rule established in Bellis Hess for some time. See addendum to brief of 4 United States Senators as Americae Curiae, compiling efforts by Congress between 2001 and 2017 to pass legislation respecting interstate sales tax collection. These bills addressing the issue are currently pending. See Marketplace Fairness Act of 2017 if you want to fall asleep, that is, or the Remote Transactions Party Act of 2017. Again, if you have a hard time sleeping at night, you can read this stuff. I do, so I read this. So, in any event, no regulation without representation act. That's HR 2887, 115th Congress, first session, 2017. Anyway, we continue. Nothing in today's decision precludes Congress from continuing to seek a legislative solution, but by suddenly changing the ground rules, the court may have waylaid Congress's consideration of the issue. Armed with today's decision, state officials can be expected to redirect their attention from working with Congress on a national solution to securing new tax revenue from remote retailers. Overturning Quill would undo much of Congress's work to find a workable national compromise under the Commerce Clause. The court proceeds with an inexplicable sense of urgency. It assents that the passage of time is only increasing the need to take the extraordinary step of overruling Bellis Hess and Quill. Each year, the physical presence rule becomes further removed from economic reality and results in significant revenue losses to the states. The factual predicates for the assertion include a Government Accountability Office (GAO) estimate that under the physical presence rule, states lose billions of dollars in sales tax revenue. Citing the GAO report to congressional requesters, sales taxes, states could gain revenue and expand authority, but businesses are likely to exercise compliance costs. But evidence in the same GAO report indicates that the pendulum is swinging in the opposite direction and has been for some time. States and local governments are already able to collect approximately 80% of the tax revenue that would be available if there were no physical presence rule. Among the top 100 internet retailers, that rate is between 87 and 96%. Some companies, including the online behemoth Amazon, now voluntarily collect and remit sales tax in every state that assesses one, even those in which they have no physical presence. To the extent the physical presence rule is harming states, the harm is apparently receding with time. The court rests its decision to overrule Bellis Hess on the present realities of the interstate marketplace. As the court puts it, allowing remote sellers to escape remitting a lawful tax is, quote, unfair and unjust, unquote. Unfair and unjust to competitors who must remit the tax, and to consumers who pay the tax, and to the states that seek fair enforcement of this sales tax. But the present realities of the interstate marketplace include the possibility that the marketplace itself could be affected by abandoning the physical presence rule. The court's focus on unfairness and injustice does not appear to embrace consideration of that current public policy concern. The court, for example, reasonably discards the costs that the decision will impose on retailers, correctly calculating the remitting sales tax on all e-commerce sales will likely prove baffling for many retailers. Over 10,000 jurisdictions levy sales taxes, each with different tax rates, different rules governing tax exempt goods and services, different product category definitions, and different standards for determining whether an out of state seller has a substantial presence in the jurisdiction. A few examples: New Jersey knitters pay sales tax on yarn purchased for art projects, but not on yarn embarked for sweaters. Texas taxes of plain deodorant at 6.25%, but imposes no tax on deodorant with antiperspirant. Illinois categorizes Twix and Snickers bars, chocolate and caramel confections, usually displayed side by side in the candy aisle, as food and candy, respectively. Twix have flour, Snickers don't, and taxes them differently. The burden will fall disproportionately on small businesses. One vitalizing effect of the internet has been connecting small, even micro businesses to potential buyers across the nation. People starting a business People starting a business selling their embroidered pillowcases or carved decoys can offer their wares throughout the country, but probably not if they have to figure out the tax due on every sale. See Sales Tax Report 22, indicating that costs will likely increase the most for businesses that do not have established legal teams, software systems, or outside counsel to assist with compliance related questions. And the software said to facilitate compliance is still in its infancy, and the capabilities and expense are subject to debate. Sales Taxes Report 16 through 20, concluding that businesses will incur quote unquote high compliance costs. Okay, great. The court's decision today will surely have the effect of dampening opportunities for commerce in a broad range of new markets. A good reason to leave these matters to Congress is that legislators may more directly consider the competing interests at stake. Unlike this court, Congress has the flexibility to address these questions in a wide variety of ways. As we have said in other Dormant Commerce Clause cases, Congress has the capacity to investigate and analyze facts beyond anything the judiciary could match. Here, after investigation, Congress could reasonably decide that current trends might sufficiently expand tax revenues, obviating the need for an abrupt policy shift with potentially adverse consequences for e commerce. Or Congress might decide that the benefits of allowing states to secure additional tax revenue outweigh any foreseeable harm to e commerce. where Congress might elect to accommodate these competing interests by, for example, allowing states to tax internet sales by remote retailers only if revenue from such sales exceeds some set amount per year. See Goldlap Brief 12 through 14, providing varied examples of how Congress could address sales tax collection. In any event, Congress can focus directly on current policy concerns rather than past legal mistakes. Congress can also provide a nuanced answer to the troubling question whether any change will have retroactive effect. An erroneous decision from this court may very well have been an unintended factor contributing to the growth of e-commerce. The court is, of course, correct that the nation's economy has changed dramatically since the time that Belus, Hess, and Quill roamed the earth. I fear that the court today is compounding its past error by trying to fix it in a totally different era. The Constitution gives Congress the power to regulate commerce among the several states. I would let Congress decide whether to depart from the physical presence rule that has governed the area for half a century. I respectfully dissent. So I thought this was a really interesting case for several reasons, in fact. And if we were just to look at the sales taxes, they're kind of a recent advent, if you will. The first sales tax was collected by West Virginia State in 1921, and then in the 1930s, or 1933, in fact, there were 12 states that had sales tax, and then by 1940 there were 18 states, and not every state today collects sales tax. New Hampshire actually doesn't collect a sales tax, but it's actually they get you in other ways. So the problem I think with at least here in Massachusetts, where I'm from, people go up to New Hampshire to buy their goods to avoid the sales tax. I'm shocked. I'm completely shocked at that. No, not really. And that actually creates a problem for Massachusetts, the Commonwealth of Massachusetts, because they don't get that sales tax exactly. I mean, people dodge it all the time. They say they give out papers and all that, but that's not. I don't really see that happening all that often. The other thing too is that if we were to look at sales taxes and taxes in general, something really interesting happened in 1913 with the hobby, in fact, and that was the implementation of the 16th Amendment, and that required that corporations had to pay a small percentage of taxes, and also people had to pay taxes on their income as well. And this was actually tried back in 1895 with the Harvester Trust case, and that was actually deemed unconstitutional in 1896. And actually, that portion of the Harvester Trust and Loan Act, I think that's what it was called, that was actually enacted by this gentleman right here. This is Arthur P. Gorman, and he's in the 1888 presidential possibilities set. I'm not sure how much of a presidential possibility he would have been, but he does have some pretty major baseball connections, which is why I actually bought this card. I love this set. This is one of my favorite non-sports sets of the 19th century. And I'll show you the back of it just in case you guys have not seen this. So it looks something like this. And I think it has 25. I have a few of these actually. And you do have a couple of presidents in this set. Benjamin Harrison. I think he was about what 1889 through 1892, and then he was a general in the Civil War. Not a good president, and He really didn't have a very good personality either. But yeah, to each his own, I guess. James G. Blaine, I think he was a, if I can remember right, I think he was a Secretary of State or the Secretary of the Treasury. I'll have to go back and check that out, but he is kind of a pretty famous guy. And then you have Robert T. Lincoln, and you guys should know who that is. That's the son of Abraham Lincoln, and he was a corporate lawyer. I think he only held a minor office only once, and he really didn't like politics. Who can blame the guy, really? There's another guy here too, Chauncey Depew, and you're probably like, who the heck is that guy? I know, I didn't know about the guy until a couple of years ago, but what I thought was kind of interesting is that he's the second longest living person on this list, this checklist. Uh, Robert T. Lincoln passed away in 1929, and DP was in 1928 at the age of 93, 94. And he gave a really interesting interview in about 1925 or so. And I guess they asked him, how did you live so long? So like I think in 1925 he was 90 years old, and that was really impressive. I mean, it is impressive to be 90 years old. If you can get to be 90, you're most likely going to be 100 or reach there. So, 1925, when he was 90 years old, he said that he cut down on the cigars. I believe he was smoking like 25 a day, or he maybe I think he even picked up cigarette smoking or tobacco smoking at an old age. I'm not going to be doing that when I'm 90. uh, I don't think so. But, hey, to each his own, right? I mean, everybody needs a hobby. Um, so he did that, and then he cut out steak, and he went to poultry, and he said he just couldn't handle the steak, and it was too heavy, I guess. So good on him, he was kind of a health conscious guy, and it's one of the reasons why he said he lived so long. If he's 90 years old and he's smoking 25 cigars a day, um, you're you're not going to live all that long. And not today anyway. The tobacco back in 1925, they didn't put all those additives and preservatives in that stuff that they do today. They did put in stuff, uh, but it was not nearly the kind of stuff that they're putting in today. And on top of it, the leading cause of cancer in the United States in say 1930 was not lung cancer, which you would get from smoking cigarettes or tobacco products. I myself have never smoked a cigarette in my life. Um, I have had a couple of cigars, but I kind of pride myself in not having a cigarette, and I honestly, it's kind of strange because I do talk about tobacco and tobacco products and T206 and T205s, and I know a lot about tobacco because of cards like this. In fact, here it is, the T206. And what's also really interesting about this set is that on the back of these cards there is a a factory number and a district number. And actually, this one's a little bit different because there is, if you guys can see this, there is this, I don't know, it's a bar or something. I still have yet to figure out exactly why that is on here, but there are a few of them. I think this is factory 42. It's in the 354 or yeah, 350, 450 range. Any, anyway, with this card, actually, on the back, like I said, the factory number and the district number, they correspond with the tobacco product itself. And it was a way for the revenue service. Now, they weren't the Internal Revenue Service then, but they were the revenue service. Very close enough. It's just a name change. Each one of those corresponded, right? So it was easier for the revenue service to trace every package to where it was going so they could collect the taxes. I actually put this into my look into the T206, and it's the rise of the T206. And with that, the American Tobacco Company was sued by the government in 1907, beginning in 1907, and they kind of evaded taxes up until, I believe, on 1907 or so. But going back to at least 1898 with the war with Spain and Cuba, so they were avoiding their taxes, and that's, I think, one of the things that the government did kind of go after was there was a paper trail that led to this, and it was in this is the this is the report on the tobacco that government went after them, and in this, it's really a kind of like a how-to on not to conduct business, but it kind of details everything that was going on with the American Tobacco Company, and it details how many packs or packages or pounds of tobacco were being released to the public by this company, and by, I'd say, 1903 or so, the company had at least 98% of the tobacco market. And on top of that, they would also have uh, equally 98% of the ball players by, say, 1909 to 1912, signing contracts with the lithograph company, American Lithograph, that is. And so not only did they hold the monopoly on tobacco, but they held the monopoly on tobacco cards, specifically baseball. So they never went after the company for its monopoly on baseball cards. But in 1912, there was an Illinois senator named Thomas Gallagher who had asked Congress to look into a monopoly in baseball, and he brought it up on the House, I think it's the House floor, and they said, nope, we're not going to investigate that. Although he was probably more than 100% right that baseball did have a monopoly. That actually was the first time that they looked into baseball as a monopoly, and then that kind of well, obviously it preceded the 1922 Holmes decision on baseball as a tax exempt entity, if you will. So this thing, it really does an amazing job at finding out how many cigarette packs came out in every single year. The problem is that it doesn't tell you the exact, for the most part, it doesn't tell you the exact brands. They were not really, I don't think, interested in all of their brands. Now, there is another document or book that I have seen that lists every single brand that the American Tobacco Company issued, and actually, I think all tobacco companies issued, and I think that's from like the 1950s or so, or maybe the 1960s or 70s, and it tells you what the brand is, when it was first released, and when it was discontinued. Now, I'm not entirely convinced that it is accurate. I just don't know the accuracy of it. And I try to do as much research on these brands as much as possible, but it's very, very difficult. Sometimes there's a hard push for the tobacco brands and a giant advertising campaign. And then sometimes they're just kind of like sneaky about it, and boom, there they are out in the public. And then a lot of times you don't know when these brands actually ended. A great topic of debate among really kind of people who do collect the T206, T207s. The only really reason why we know about a lot of those brands that are advertised on these cards is because of the cards themselves. 9 times out of 10, you're not going to know about the brand itself because and unless you're a tobacco pack enthusiast, um, a lot of them are kind of lost to history, to tell you the truth. And obviously, nobody's around from like the 1910s or 1920s to tell us about the tobacco itself. When I'm researching this stuff, I'm really kind of finding out for the first time as well. And I want to know about this stuff. I really do. I really find it very fascinating. So that's one portion of it. Uh, what I was getting at, sometimes sometimes I'm all over the place, as you guys know. But the the one thing that I wanted to tell you guys about this, which is probably the most important, and I can't believe I just kind of lost my train of thought. Just went anyway. Um, so the government actually got its taxes three ways when the T206 was first being issued, and that was through the sin taxes. It was alcohol, it was tobacco, which is this right here, and it was through tariffs. And these three things made up the majority of taxes for Uncle Sam. And it was not the sales tax, because as I just said prior, that the sales taxes were first implemented in 1921 through 1940, and then after that, and then today, not every state has a sales tax. So the other thing I wanted to mention here about Arthur P. Gorman was that he did have his own tariff, but it was like kind of discontinued, and most tariffs actually only lasted two to 4 years. It was very rare that you'd have a tariff last more than 2 years. What he is really kind of known for in baseball circles, though, is the fact that he founded the Washington Nationals, or the Washington Senators, in 1859. He was a young ball player playing for the Nationals, in fact, in 1859 through 1867. And he only quit because his future father-in-law said, "Hey, listen, you can either marry my daughter or you can play baseball, but you can't do both." And so he decided, you know what, I love the woman more than I love baseball. And so he chose a path through politics, through his bride and her father. So he also was on the Mills Commission I believe, in 1903. So he passed away in 1906, but in 1903 they had the Mills Commission, which was a commission to study uh, how baseball formed and when it formed. And it's not the most accurate thing in the world. The report itself went missing, believed to be up in smoke in a fire in 1916. And in 1999, the curator of the Baseball Hall of Fame actually found the report in a box that was delivered to the Hall of Fame. That actually, the box itself is kind of interesting because there was a 19th century ball player who apparently had this. And I'm not entirely sure like how, because I think he died in the 19th century, and this is a report from like 1907, I think. And so they said that baseball, in this report, they said baseball was an American sport, and so that's how you get the national pastime. And it was really kind of debated between two people at Delmonico's, beginning in I think 1893 or so. Um, and so it was, Abner Doubleday, and nobody believes that Abner Doubleday invented baseball, and baseball was around back in 1744. And they have journals that specifically state that, and then they have some other evidence as well. But there's two different versions of baseball apparently. There's the, I think, New York rules baseball, and then I think the Massachusetts rules. And in fact, there's a sign that they have from 1791 that says "No baseball allowed," and that's, near a church. So the origins are not well established, and even if it was, you have Doc Adams playing baseball in 1831, and he's actually I don't know if you can call him a founder, but he's the first shortstop, and he did a lot for baseball. He should be in the Hall of Fame, in fact, and he's not, and you know that's not right. He was playing baseball in New York in 1831. So how can you have someone playing baseball in 18 for the first time? So I don't understand how you can have Abner Doubleday playing baseball in 1839 when you have Doc Adams playing baseball in New York in 1831. It makes a great story, but it's not accurate. Doubleday didn't even really know about baseball for the most part. He may have seen it play during the Civil War, but he was also a very good friend of Abner Mills, who is the head of the Mills Commission, which actually never sat. So that is, in fact, why I bring up this gentleman as well. So he's actually kind of important. And there's another really big name to this as well, and it's John Sherman. And John Sherman, obviously, you've heard of the Sherman Act. That was from 1890, and it's all about trusts and monopolies. And it's what brought down eventually this company right here. Now, in 1888, this was actually the Duke and Company. So the next 2 years, it would transition over to the American Tobacco Company by taking over uh, at least five large plants, if you will, five different companies, including Allen and Kenter. And that was, I believe, in January 1st of 1890. And eventually, in 1912 or 1911, they were broken up. But there is a catch here. The court, they didn't know how to successfully break up a company of this size. It took them a long time to do so, and getting back to the court system here, in this court case, the court that Robertson is on, they're talking about this case really taking like 50 years from its first implementation and other cases, and it's kind of like going through the motions over 50 years. There's a process here. Sometimes the courts are not understanding the technology as it's progressing, right? And this is happening with photography as well in the early 1900s. So you can look at this and say that, on one hand, Roberts is saying that Congress needs to get involved in this and change the laws as they're supposed to do um, in order to evolve with technology. And this also is something that I think a lot of courts uh, didn't understand as well. New technology always brings with it uh, unexpected problems in society, just like the photograph did back in the late 1800s and early 1900s. And that actually brought about changes in the right of privacy, which Johnny Mize ended up taking Gum Products Inc. To court in 1941 because he saw his photo, his likeness on a 1941 double play. I still haven't figured out which one it is. I think it's his mugshot, not the full body pose. That's what I think. But in any event, I mean, Congress really doesn't do a very good job at addressing a lot of the issues going on during today. And I think they had it right in 1992. I think they got it wrong today when they kind of like upended Quill from 1992. And, in the Constitution, in the Commerce Clause specifically states that you have to have a physical presence within a state to collect taxes. That's, I think, a 10th Amendment issue. But, Quill was overturned, and now eBay has really kind of full authority to collect taxes. And my question is, and I'm wondering about this, maybe you guys can fill me in here. Is eBay collecting the correct amount of taxes, and where are these taxes going? Can we follow the money, right? Here's what's actually going on as well, which I don't think anyone has really thought about at the congressional level, because they're not buying sports cards, right? So I don't know any congressman who actually is in the hobby. Maybe there are a few. I don't know of any. I think there was one or two back in the 1970s with the 1973 Hobbies Act. However, um, what usually tends to happen is that if I buy this card for say $125, now I have the sales tax added onto that, whatever it is, and it turns into a larger amount. And then I have other taxes as well. Anything else that's added to that original amount, I have to now sell that card for a lot more than what I paid for it. And that's okay, I guess, but the problem is now that card, it may have been topping out at $125 in the price guide, but I have to sell it for a lot more than what it's actually worth, and a lot of times I don't think it's worth that. So, uh, again, eBay takes two chunks out of uh, your card sale, and you guys who sell on eBay know this better than I do. I'm only hearing this from third hand because I don't sell my collection. I don't sell cards. I can remember how sports cards and the hobby was when I was a teenager and even prior to that. So I started collecting when I was 5 years old in 1982. And then by 1984, I was a full-fledged card collector. And then in 1994, I switched over to vintage. And all that time, I saw the hobby grow and become what it is today. And the evolution of the hobby, really, if you think about it, it only goes back to, say, maybe 1975, right? Definitely by 1981, the hobby is much different than it was when Jefferson Burdick first started the hobby here in America in 1935. It's vastly different, and uh, if you could see it on a graph, uh, you would see a line from like 1935 through say 1980, and then from like 1981, it just goes up. So, and then in like 2020, it goes up even more, and then it crashes a little bit. And for the most part, um, I have seen some amazing things in the hobby, and I never ducked out of the hobby. I never dipped out, so I was always in it. I may not have really paid too much attention to the modern hobby for the last 20 years, but I um, I see what's going on in the modern side of the hobby, and it's not much different than what went on in the 1980s. And we're kind of cyclical now. We're seeing it again because they're repeating things that I have seen. Just the only difference here is the technology. So when I was a teenager, we didn't have something like what I'm doing now. I could never have been on video like this and doing my own production, if you will. So I would never have been able to do that. The microphone here, yeah, right. I mean, this would have been a huge production back in say 1992 or 1995 or 1998, even in 2012, right? So if you think about it, the internet as we know it today is really only 25 years old. They say that information is literally at the tips of our fingers, yet what I'm looking for does not exist or is buried so deep that I need a shovel and a pickaxe to try to find it. I do come up with some incredibly nerdy documents, stuff that nobody in their right mind would ever want to read. Yet, if it has something to do with the hobby, I will read it. And for the most part, I'm spending a lot of my days reading, and all in order to make the hobby a little bit better educated, And in the meantime, I'm becoming a little bit better educated or more educated as well. I hope so. Sometimes I kind of wonder about that. However, guys, uh, I want to hear what you guys have to say about this stuff. And was Judge Justice Roberts correct in his assessment? Obviously, uh, we have a sales tax which isn't right. It's not correct. I don't mind paying taxes. I never did, but I want my tax dollars to be a little bit more responsible. I want the people who implement my taxes to be more responsible and understand the consequences of their actions. At some point, I think we're going to have to fix the tax code. In 1940, there was only 3 pages that you had to fill out for your taxes. Today, there's a lot of things that you can miss on your tax forms or not deduct. And it takes I guess a real genius. It's a good movie, by the way. Anyway, the other funny thing too, that was just I was just thinking about the retired ball players like Mickey Mantle and Ted Williams and Joe DiMaggio and Willie Mays and Duke Snider and all those guys, Bob Feller especially. When those guys were first doing card shows and autograph shows, um, at least 3 of those guys were not paying their taxes on their autographs because it was income. And so Duke Snider, Willie Mays, and Mickey Mantle were all banned from baseball for a year. I think that was in about 1984. I could be wrong on the date there, but it was the early 80s. And so you are supposed to have IRS agents. At least I've heard that there are IRS agents at card shows to try to track down missing money, if you will, or people not paying their taxes on sales of sports cards at shows. I've never seen an IRS agent. I'm not sure what an IRS agent would look like. I kind of tend not to want to know either, but it's supposed to happen. Whether or not it does, I'm not sure. And the thing about the evolution of the hobby now is that the internet has made it easier to grab sports cards, whereas during my day, um, it was really kind of like you had to go to a card show or a card store and see what was there, but it was always limited to especially in a card shop uh, as to what the dealer had, and if somebody came in with a set of cards or whatever, and that's for vintage. For modern, it was a lot easier, I think, except for maybe the mid 1980s when people were complaining that Don Russ was really kind of like limiting their product. I mean, that's a whole different subject, but the 1980s hobby is a heck of a lot different than it is today. I think it would be unrecognizable in a lot of ways. But this is what I'm talking about when it comes to the evolution of the hobby. I actually think it's a very fascinating study that the hobby is, and I think it's almost as fascinating as taxation. I'm just joking about that. There's nothing fascinating about taxes, to tell you the truth. So I don't really want to put you guys to sleep. My eyes are kind of glazing over like donuts right now, talking about taxes and the legal system, as it usually does. So, guys, thank you so much. I really appreciate it. Give me a like and subscribe if you will, and that way I get to bore other people with my card talk here. I'm just joking about that. I really do love to hear what you guys have to say, and I always try to respond as much as possible. So, with that, guys, I will talk to you later. Have a good one. Bye.